Hello, I'm Sarah Thompson-Copsey. Welcome to today's MBL webinar on the Landlord and Tenant Act 1954, and we're looking at renewal terms today. So the Landlord and Tenant Act 1954, of course, gives to tenants in occupation for business purposes security of tenure. And that means that when their lease comes to an end, they're entitled to remain in the premises. Their lease runs over, becomes a statutory continuation. But they're also entitled to take a new lease. And so if the landlord chooses to end the tenancy by serving a Section 25 notice, bringing the tenancy to an end, or if the tenant itself wishes to do the same, but by serving a Section 26 request for a new tenancy, then unless the landlord can oppose one on one of the statutory grounds of opposition, then the landlord must grant the tenant a new tenancy of the premises if it wishes to take a new tenancy. And the Act sets out what the terms of that new tenancy should look like. And it does so in 4 sections of the Act. So Section 32 of the Act is looking at the property that's demised. Section 33 of the Act is looking at the lease length. Section 34 of the Act looks at rent. Now, we're going to be dealing with rent last rather than third here, or rather we'll deal with it just before we look at other recent 54 Act news. We'll be looking at rent quite late, simply because in order to assess the rent, well, 2 reasons really. In order to assess the rent, the court must have regard to the terms of the tenancy, so we need to know what the tenancy is before we can look at the rent, and also because it's very much a valuer's area looking at the rent, so it's not a legal area at all. But our input as lawyers is strong. We need to make sure that the evidence that's put before the court is in the right format. In other words, that we've got the right valuer who understands their duties to the court.